Hello, everyone, and welcome. Thank you for joining us for today's webinar entitled Fashion Year in Review 2021. Before we get started on today's presentation, I'd like to go over a few housekeeping items. Questions can be entered via the Q&A widget open on the left-hand side of your screen. We will address questions at the end of the program, timing permitted. The recorded version of this presentation will be available on Foley.com in the next few days, and you can find a copy of the slides in the resource list widget on the left-hand side of your screen. Foley will apply for the CLE credit after the program. To be eligible for CLE, you will need to answer the polling questions during the program. If you did not supply your CLE information upon registration, please email it to John Mesquia at jmesquia@foley.com. Certificates of attendance will be distributed via email to eligible participants approximately 8 weeks after the web conference. Note to those of you seeking Kansas, New York, and New Jersey CLE credit are required to complete the attorney affirmation form in addition to answering the polling questions. Please email the form in the resource link to John Mesquia at jmesquia@foley.com immediately following the program. Thank you, and I will turn it over to Laura.
Thank you, Ray. Welcome, everybody. I am Laura Ganoza. I am the co-chair of the Fashion, Apparel, and Beauty Industry team, and I'm so happy to be presenting our 4th annual Fashion Law Year in Review. This is a signature event for our Fashion, Apparel, and Beauty team, our Foley Fab team, as we call it. It's where we talk about the most impactful cases and issues of last year in the fashion and beauty industries. And I'm thrilled that you all join us here for the 4th go-round in doing this. Here today, I have 2 of my colleagues. First, we have AJ Schumacher. He's making his debut here on this edition of our Fashion Law Year in Review. He's one of our superstar lawyers from our trademark, advertising, and copyright group. And he's also a lover of fashion. So he's been following these trends along with me all this year, and is excited to present them to you today. We also have Jenny Wang. She is one of our business lawyers, and she's part of Foley's supply chain industry team. And she's one of the architects of Foley's Blockchain in the Supply Chain series. And this is a series that provides articles on all kinds of different legal developments in blockchain technology. And we thought it would be really important to have Jenny's view here this year, because I don't think you can talk about 2021 without mentioning NFTs or blockchain. So this technology is becoming increasingly important, and especially in the fashion industry. So we're really glad to have Jenny join us today and give us some insight on this technology, how it affects our industry. So a lot has happened in 2021, and a lot in the fashion and beauty industry that we're going to cover here today. There's some Supreme Court action that's taken place where they have granted certs, another case where they haven't. We'll talk about those. We also have a little update on our cases to watch, cases that we brought up from the prior year, and we keep monitoring to see what's going on with them. So we'll catch you up on all of those and other ones that have happened this past year, including, of course, the Nike case with the Satan shoe and a bunch of other cases that we'll all remember that happened this year. But in addition to the cases, there's also just some trends that are happening in fashion that have some legal considerations that practitioners in this field should know about, like blockchain technology that I mentioned that Jenny will be talking about, sustainability, also the metaverse, digital fashion, smart fabrics. All of these innovative technologies are really affecting the fashion industry, so it's important to talk about them and their legal implications. And also, as we end every year, we'll also give you some previews on cases that we're going to be watching in 2022 that we believe are going to be impactful in this industry. So first, let's start with a case where the Supreme Court decided to take some action. If you'll remember from our prior, some of our prior years in review, we mentioned this Unicolors case against H&M. It originally started out in district court in California, where Unicolors sued H&M, claiming that that H&M was selling jackets and skirts using a copyrighted textile fabric that's shown right there without their authorization. Ultimately, that went to a jury trial. It found in favor of Unicolors and awarded them around $800,000 against H&M. H&M tried to argue in that case, well, this whole verdict should just be vacated because the underlying registration certificate that covers this work is invalid because Unicolors knowingly included false information. Specifically, what they argued is that Unicolors listed January 15th, 2011 as the date of the collection of the works in order to file a collection of works as a single unit registration. But the evidence showed that actually there was a dispute as to whether or not everything was done at the same time. Apparently, some items were put in a showroom, other items were quote unquote confined, meaning that it was kept private only to some customers and not shown to everyone. So the question really was, what happened? Was everything made public at the same time as required in order to be able to take advantage of filing a collection of works? H&M argued that it wasn't. The district court rejected that argument and said, you haven't shown that there was an intent to defraud. There were some works that were in the showroom, so that doesn't mean that necessarily it was fraudulent by saying that they were not all published at the same time. So H&M appealed that to the Ninth Circuit, and the Ninth Circuit reversed. The Ninth Circuit said, no, that's not the case here. In fact, the Copyright Act does not require an intent to defraud. All that there has to be shown is if there's knowledge, and they had knowledge because they knew that all of the works were not published at the same time as one bundled unit because there were these confined articles that were only shown to certain customers and not to the public at large. So specifically, that's what they held, that it was inaccurate because the works were a single unit of publication with knowledge that that information itself was inaccurate because it wasn't all done at the same time. They also remanded to the Register of Copyrights to ask if you know now that that information was inaccurate, would you have still allowed the registration? In response to that, Unicolors then filed a petition for cert with the U.S. Supreme Court, and ultimately the U.S. Supreme Court did grant cert. And really what this whole case comes down to is, what is the state of mind that an infringer is going to have to show in order to try to invalidate a copyright registration? Is it knowledge? Is there an intent to defraud that's required? So ultimately, what this is going to boil down to is, what is the meaning of the statute at issue here? And it's going to boil down to Section 411B. And 411B talks about, it basically allows a copyright registration to be effective even if there is some inaccurate information. But there's some exceptions. Unless the inaccurate information was included on the application for copyright registration with knowledge that it was inaccurate, and two, that the inaccurate information, if known, would have caused the Register of Copyrights to refuse the registration. So the second element is a materiality element. So even if it's inaccurate, would that have made a difference? But the issue in this case in front of the Supreme Court is, what does this "with knowledge that it was inaccurate" really mean? And Unicolors is trying to argue that that statute actually codified the fraud on the copyright doctrine, meaning that you have to show an actual intent to defraud. It's not enough that you knew something was wrong. You have to actually show an intent to defraud the Copyright Office. H&M, on the other side, is arguing the statute says what it says knowledge. You don't have to show that higher burden of showing fraud. And, ignorance of the law is no excuse. If you didn't know what you were doing when you filled out the copyright application, but you knew something in there wasn't exactly correct, that's enough to invalidate it. So it was pretty interesting hearing the arguments in front of the Supreme Court. They were held in November of this past year. And, Unicolors was trying to argue how the importance of the Copyright Act is really to protect artists and poets. And Justice Sotomayor said, okay, but aren't you considered a copyright troll? So why would this apply to you? And so that was an interesting colloquy on that. And ultimately, Unicolors basically had to concede that willful blindness would not be acceptable. And that would be something that could allow a copyright registration to be invalidated. Meanwhile, with H&M, they wanted, with the knowledge standard, Judge Kavanaugh asked, well, what if someone was just, literally confused? There's much confusion. You could spend years trying to figure out what publication means under Section 101 of the Copyright Act. So what if someone's legitimately confused? Is that enough to invalidate someone's copyright and their ability to go to court? Because remember, in the Supreme Court's recent decision in Fourth Estate, you have to have a certificate of registration to file a copyright lawsuit. So if you're invalidating it, you're effectively not allowing someone to go to court. So ultimately, this could have some pretty, significant implications depending on which side you're on. If the Supreme Court favors Unicolors, I think it'll be, it'll be a good result for copyright owners who may have some confusion in how they're filling out documents, and they could be safe in the knowledge, well, as long as I'm not trying to mislead the Copyright Office, if I make a mistake here or there, it will be okay, and I still won't lose all my rights. If it goes the other way, though, it's going to become even more important for brand owners and anyone filing copyright registrations to make sure that they understand what they're doing, get legal advice, and make sure you do it right. So hopefully we'll get some kind of decision on that coming up this summer, and we will keep you updated on that when we do. But in the meantime, there's another case that the Supreme Court decided not to take cert. So now we have a final decision on that, and I'll let AJ take it from here. AJ.
Sorry, I was on mute. I'm still learning.
Okay.
So now we turn to a case involving everyone's favorite boot, which is the UGG branded boots. This case involves Decker Outdoor versus Australian Leather. And Decker is the owner of the UGG brand in the U.S., and they filed a lawsuit against trademark infringement against Australian Leather over their sale of UGG boots to U.S. consumers online. In response to the lawsuit, Australian Leather claimed effectively that UGG is a generic term because it refers to a sheepskin type boot, and it's therefore generic and invalid, or the registration is invalid. They've tried to make like an interesting argument over the doctrine of foreign equivalence. They pretty much base the genericness argument on the fact that UGG is a generic term in Australia, and that because of that, it should be given as treated under the doctrine of foreign equivalence as being generic in the U.S. But in September 2018, the district court rejected that argument and effectively said that generic meaning is considered based on U.S. consumers, and granted Decker's motion for summary judgment on the genericness issue. And then the jury later found that Australian Leather had infringed Decker's trademarks because they're selling these boots, as you can see, that pretty clearly have the identical mark on there, and then awarded Decker's $450,000 in damages. Australian Leather appealed to the Federal Circuit, which affirmed in a pretty quick decision, I believe. And then Australian Leather, with support of the Australian government, petitioned to the Supreme Court in October 2021. Their position was their argument was that there was a circuit split as it relates to the doctrine of foreign equivalence and genericness. And they alleged that that circuit split resulted in an unjustified conclusion that although generic terms in foreign languages cannot be trademarked, the same rule will not be applied to generic terms that originated in other English-speaking countries. And their main question that they presented, as you can see to the right, is whether a term that is generic in an English-speaking foreign country from which it originated is ineligible for trademark protection in the U.S. The Supreme Court decided not to hear the case in December 2021, which is a decision I think is probably right because it doesn't seem like I wasn't buying the foreign equivalence argument anyway. But so what we can learn from this case is effectively for foreign companies looking to sell products into the U.S. To carefully analyze trademarks or potential trademarks and their foreign equivalents, obviously, and then just be aware of U.S. trademark rights for terms in the country of origin that might be generic but may not be in the U.S. And similar considerations apply for U.S. companies in foreign jurisdictions. And then a couple fun facts that I thought relevant for this case was that, as I mentioned earlier, the Australian government apparently backed Australian Leather, I think, financially, and then they also submitted a brief in support. And one of their interesting quotes from the brief was that the Australian government was concerned with the apparent discriminatory treatment that Australian goods would receive from a rule that prevents the trademarking of generic terms of only non-English speaking foreign countries. So the Australian government was apparently trying to get this term back for that other Australian companies can use it in the U.S., but not going to happen. So, all right, the next part of the presentation deals with prior cases to watch, and this discusses updates and conclusions on some notable cases that we've been monitoring in prior years in review. So with that, I'll hand it back to Laura to discuss Chanel.
Thanks, AJ. So yes, we've been monitoring this case. Actually, there are two cases filed by Chanel involving the luxury resale or secondary market. And these cases are really important, I think, for a number of reasons. There's really a shift of consumer preferences on the importance of sustainability in fashion. And I think there's going to be a continued growing market for consumers wanting to, engage in this secondary and resale market. So this market's not going to go anywhere, and it's going to be important to see what happens with this case. In fact, I was looking at a study recently that said 59% of luxury consumers in both the primary and secondary market say that sustainability influences their purchase decision. And it makes sense on both sides, right? So if you buy a beautiful Chanel bag or Hermes bag, you're making an investment knowing that this is going to be a bag that could potentially be for a lifetime, and you don't have to buy a new one every season necessarily. So on that side of the coin, a primary purchaser can be thinking that they're doing something that sustainability affects their decision, just like on the other side, when somebody buys something from the resale market, they're believing that they're reducing carbon emissions because they're not buying a new one. So both players in this market have, to some extent, are taking into account sustainability. So what are these two cases about? In 2018, Chanel sued two resale markets, The Real and What Goes Around Comes Around, for trademark infringement and counterfeiting. And although there's a bunch of different claims in both of these lawsuits, which are pending in the Southern District of New York, they really boil down to two types of claims. One is that these sites are engaging in the sale of counterfeit products, and that's a violation of the Lanham Act. Second, they also claim that these markets are engaged in deceptive advertising because the way that they market their products leads a consumer to believe that there's a connection somehow between The Real and Chanel, or What Goes Around Comes Around and Chanel. Specifically, they're saying representations like these products on our sites are 100% authentic, or guaranteed authentic, or the most trusted source for authenticated luxury resale. All of those are literally false because, first of all, there's evidence of counterfeit products. And the way that they're branding it makes it seem that there is some kind of connection to Chanel when, in fact, there isn't. So where are we with these cases? In The Real, there's been a lot of back and forth going back with amended pleadings and motions to dismiss. Ultimately, The Real answered. But what happened last year that was a development was that in addition, The Real filed an amended counterclaim, and they're accusing Chanel of antitrust and other anti-competitive counterclaims, basically saying, well, you let others be able to sell on the secondary market where you have an interest, but you just want to squelch competition when it comes to these markets. So they've been going back and forth. And at some point last year, the case was stayed so the parties could participate in mediation. Ultimately, it seems like that didn't happen and they weren't able to reach a settlement. And as of this morning, when I checked, right now, the parties are still supposed to be going to proceed with the case. There'll probably be a ruling on the motion to dismiss the counterclaim, and fact discovery and expert discovery is going to need to be done by August and November, respectively. So we'll see if there's an ultimate decision. Similarly, with the What Comes Around Goes Around case, there was less motion practice on the pleadings, but the discovery that the defendant was doing in that case was similar to this notion of what this case is about is really an attempt to squelch competition. And in that case, it's a little more further along in terms of dispositive motions. Motions for summary judgment has been filed, and when I checked this morning, they still haven't been ruled on yet. So this is definitely something that we're going to keep watching because there's this tension. There's this, underlying tension between a brand owner's right to protect exclusivity, especially a luxury owner like Chanel, their right to protect the exclusivity and maintain the quality of their brand. But you also have a public interest in having sustainable options and having a resale market to be able to sell their goods, especially, under the first sale doctrine, after they buy it. So this tension is something that has, real legal implications. But in addition to that, as a practical matter, like I mentioned at the beginning, this is not going to go away. And some other brands are actually recognizing this, and they're creating their own resale channels. For example, recently, Steve Madden collaborated with a platform called Recurate, and they've had their own a channel now called Rebooted, where you can exchange or sell your nicely and softly used Steve Madden shoes. And so they're creating this circular community for footwear. And I think that we're going to see a lot more of that continue just because of the difference in consumer preferences. So stay tuned. We'll see what happens in this case. But I'm going to hand it over to AJ so he can talk about a Nike case that we previewed last year.
Yeah. So we previewed this case last year. It was where Fleet Feet sued Nike in the summer of 2019 over a campaign ad featuring the slogan "Sports changes everything." Fleet Feet alleged trademark infringement of its "Running changes everything" and "Change everything" trademarks. The district court ultimately granted a preliminary injunction in December of 2019 in Fleet Feet's favor. It caused Nike to have to put a pause on its campaign ad featuring the slogan that was supposed to run through the 2020 Super Bowl with a price tag of allegedly around $20 million. So in February of 2020, Nike appealed. They argued that the preliminary injunction was not warranted because the district court committed legal errors in recognizing that Nike's fair use defense and that they were using the mark in a descriptive, non-trademark manner. The other Fleet Feet effectively responded and said, "There's no difference between your use of sports changes everything and your other taglines, like just do it." Obviously, that's their famous one. And then in January 2022. Or January 2021, there was an appeal to the Fourth Circuit. And the Fourth Circuit handed Nike what is effectively another loss. They told them that the preliminary injunction issue became moot because Nike's campaign was only supposed to run through the 2020 Super Bowl, and Nike hadn't used any similar slogans in the meantime and effectively committed not to doing so. And then in April 2021, the parties effectively settled, and the district court judge vacated the order blocking Nike from running allegedly infringing ads. And then the settlement resolved the litigation and the related TTAB proceedings. I believe that Nike moved to cancel the Fleet Feet's registered marks. So. Moving on to the next section. This is other notable cases and updates in 2021 just that we've been following. So the first one is another Nike case that is interesting, not only because I like Nike shoes, but this one made a lot of headlines. In March 2026, there was a tweet, a Twitter post about a shoe collaboration with MS Chf, which is like the small Brooklyn-based arts collaborative, and they had a collaboration with the rapper Lil Nas X to make these shoes that were called the Satan shoes. The shoes were set to release 3 days later on March 29th. And I'm not sure if anybody's familiar with this company, but they tend to do this, I think, fairly regularly. They took a Nike Airmass 97 and they customized it with a bunch of satanic themes. So, for example, they added red ink and a drop of human blood to the midsole. They also had some other symbols like an inverted cross and a pentagram. The tweet made generated a lot of press coverage and discussions of Nike's involvement, and there was, as you can imagine, a lot of backlash over it because of the satanic themes. So on the day of the release, Nike ended up suing MS Chf, alleging trademark infringement, false designation of origin, and dilution. Nike's position was effectively that the customization went too far and resulted in a non-genuine, unauthorized Nike product that would likely cause consumer confusion and dilution, especially because, as you can see, Nike's logos were still on the shoe in a prominent manner. And in the complaint in support of its position, Nike cited various online commentary calling for boycotts of the brand. I don't know if everybody can read all of those, but I'll read them anyway. One person said, "This is terrible, won't buy Nike again, you are banned." Anonymous said, "No more Nike for anyone in my family." And then Michelle, I don't know where Michelle's from, said, "I'm appalled. Words cannot describe the amount of disgust and disbelief that is truly happening. Jesus, please save us. Never supporting or buying Nike again." And there was, in the complaint, they listed a number of other similar comments. So MSCHF responded to the lawsuit by effectively selling all of the shoes except for one pair, and then argued in response to Nike's TRO request that their work was protected by the First Amendment as an artistic expression and satire. They were allegedly commentating on what they considered the obsessive collaboration culture that is apparently going on in fashion right now. So the district court eventually sided with Nike and they granted the TRO prohibiting the sale of these Satan shoes. The order didn't, however, require MS Chf to recall any of the Satan shoes already sold. So, a lot of the damage was already done. And then the parties then quickly settled thereafter. And so what we can learn from these, I guess some of the takeaways are that this, authentic but later modified apparel is becoming increasingly popular. And brands kind of have to decide when this creative expression and customization goes too far and enforcement becomes necessary. And they also have to balance that with, how it'll play out in public opinion. So for example, as I mentioned earlier, the MS Chf, they did a shoe in 2019 that they called the Jesus shoe that also had an Airmass 97 in it. And it had kind of the similar customizations. I think they put they got water from the River Jordan and then had it blessed so that you were walking on, what is holy water effectively. And, but Nike didn't take any action, probably because I don't think that it generated quite the backlash that this one did. So another case that finally concluded in 2021 is Tiffany and Costco, or Tiffany v. Costco. And as some of you may know, back in Valentine's Day 2013, Tiffany sued Costco for trademark infringement counterfeiting, stemming from Costco's sale of engagement rings under the Tiffany name. Costco responded to the lawsuit by arguing that Tiffany was a generic term that indicates a specific ring setting. In September 2015, summary judgment was awarded to Tiffany on infringement in the counterfeiting claims. And then Tiffany was awarded a sum of $21 million by a jury shortly thereafter. Costco then appealed, and in August 2020, the Second Circuit ruled in Costco's favor. They found that summary judgment should not have been granted. The Second Circuit's reasoning was effectively that there was genuine questions of material fact as to a likely confusion. This was due to a combination of reasons. Costco has presented evidence that Tiffany was a recognized ring setting term, and also that consumers of engagement rings that are spending thousands of dollars are pretty discerning and are less likely to be confused. And then there was also a question of whether Costco used Tiffany in a descriptive sense, to indicate the ring setting. And then 2021, the case was remanded, and then in 2021, the parties eventually settled on terms that were not disclosed, and the case was dismissed. I believe Tiffany was acquired sometime recently by LVMH. I think that might be right. So I don't know if the settlement had anything to do with having a new owner or not, but. So the next section are just the hot topics that everyone in the fashion industry needs to be aware of and the related legal considerations. And with that, I will hand it over to Jenny.
Great. So let's talk a bit about what blockchain is first. Blockchain is a ledger or a collection of data that is distributed and immutable, used to keep a record of transactions. So what does that mean? Distributed means that the data is shared across multiple computer devices or nodes, instead of being stored in a single location. Each computer that forms the blockchain network stores an identical copy of the ledger. Immutable means once the data is recorded onto the blockchain ledger, it cannot be changed. The reason the data cannot be changed is because a hacker would actually need to alter each copy of the blockchain held by the different nodes on the blockchain to change the data, which would be nearly impossible in most circumstances. There are some exceptions to this rule, such as if a blockchain is spread across only a few nodes, or if the blockchain is run by a single organization. Some other characteristics of blockchain is that each blockchain transaction, which is located in a block or a set of data, is actually automatically timestamped. Blockchain transactions are also very secure, not only because of blockchain's distributed structure, but also because each block on the blockchain is individually encrypted. So blockchain technology is really fantastic for the fashion industry because the secure and time-stamped storage protocol of blockchain enables end-to-end tracking, which is tracing from one end of the supply chain to the other. Because clothing supply chains typically span many countries across the globe and contain multiple raw material sources, multiple factories that process the raw materials, multiple subcontract clothing manufacturers, et cetera, the end-to-end tracking that blockchain provides can provide transparency for the clothing supply chain. Blockchain can really help fashion companies with sourcing, sustainability, and counterfeit prevention. Blockchain for sourcing enables companies to manage and track timing of raw materials and subcomponents in the production process to facilitate production and distribution, time management, and cost projections. The tracking also allows companies to determine where along the supply chain a product gets damaged, and this allows companies to then track the components back to the original supplier. All of this is due to the visibility that blockchain provides to supply chain. Blockchain also promotes visibility so that clothing manufacturers can cater to consumers that are focused on purchasing clothing made from recycled or natural materials and inform them about the life cycle of their clothing. And finally, blockchain helps with preventing counterfeiting by identifying provenance, which is the proof of origin of a product, because blockchain can provide a secure and trusted tracking system from one end of the supply chain to the other. Companies implement blockchain provenance through the use of smart tags, which are then attached to a good and can identify the good's place of manufacture. It can track its location and assign other relevant information at each step in the supply chain. And we have some statistics on the right-hand side of this slide. In December 2021, the U.S. Customs and Border Patrol officers assigned to the Los Angeles Long Beach seaport seized over $30 million worth of fake designer products. That $30 million is if the products were sold at the MSRP of $30 million. So blockchain is a good fit for luxury brands because there's a certain amount of effort and investment that is needed to implement end-to-end tracking. Customers will need to be interested in sustainability and authenticity enough to justify the company in investing in blockchain technology. For example, the LVMH group, which houses the Louis Vuitton and Bulgari brands, partnered with two other luxury brands, Prada and Cartier, to develop the Aura blockchain consortium. The LVMH group unveiled the collaboration in April 2021 and describes it as the world's first global luxury blockchain, which has the ability to provide consumers with the ability to trace a luxury product throughout its life cycle. Now, as companies begin to implement blockchain solutions, there are some legal issues to consider. For instance, drafters of commercial contracts should give thought as to what contract terms to adjust in supply agreements and other commercial contracts as a result of implementing blockchain in the supply chain. As to data privacy, while many consider blockchain to be a highly secure means of storing data, paradoxically, blockchain's other attribute of being decentralized actually poses a potential barrier to complying with data privacy regulations. A decentralized platform permits processing of an individual's information in any number of locations around the world because an individual's personal data could exist in different jurisdictions at the same time when stored on blockchain. As each jurisdiction regulates the processing of personal data differently, attempting to manage the plethora of privacy laws, some of which may conflict with others, could be a daunting and cost-prohibitive effort. And finally, blockchain provides an avenue for competitors to cooperate. As with any collaboration or joint venture among competitors, such collaboration raises potential antitrust risks and can create a slippery slope to claims of collusion and anti-competitive exclusionary conduct. If you are interested in learning more about this emerging topic or blockchain and supply chain generally, feel free to check out Foley's series of articles located on our website. And now I'll hand it back over to AJ.
Thank you. The next thing we're going to talk about is, or next topic is sustainability in fashion. As Laura mentioned earlier with her statistic, there's, a consumer demand for sustainability is increasing and increasingly influencing consumer purchasing decisions. And at the same time, consumers are recognizing the fashion industry's role with various environmental and social issues that we're currently grappling with, particularly as fast fashion continues to boom and the industry's kind of pursuit of just growth. Some of these issues are on the slide, but they include excessive consumption and overproduction, carbon emissions, water pollution, workers' rights and compensation, especially down the supply chain and like the garment workers. So as a result, brands are making more sustainability, environmental, and social impact claims in their advertising and marketing materials. Yet at the same time, some research suggests that consumers may not really know what these claims mean. And even if they do, they don't really trust that the brands are doing everything they say that they're doing or what they're claiming that they're doing. So given all of this, there's been increased pressure lately for regulators to tighten and reconsider advertising guidance and the rules surrounding these types of environmental and social claims. So for example, in May 2021, an organization called Politically and Fashion led a coalition letter to the FTC to review the Green Guides. And if you're not familiar, the Green Guides were created in 1992, and they help businesses avoid making unfair and deceptive environmental advertising claims. They also help the public know what some of the claims companies are making actually mean. They haven't been revised since 2012, and obviously a lot has changed since then. So. So here's the last bullet kind of provides some examples of things that are currently included in the Green Guides and what are not. Notably, the things that are not included consist of sustainability, organic, and natural claims. So in July 2021, the FTC agreed and indicated that they would review the Green Guides in 2022. They didn't say exactly what areas they're going to focus on, but many suspect that they're going to finally revisit the sustainable, organic, and natural claims, as well as the level of substantiation required for environmental advertising claims. So this is just something to be on the lookout for in 2022, as the revised guides could have a significant impact on claims that companies are allowed to make in their advertising. Another thing related to sustainability to be on the lookout for in 2022 is New York's Fashion Act. This was recently unveiled in New York legislature as a bill. The bill is allegedly an attempt to hold the biggest brands in fashion accountable for their role in climate change. The proposed law applies to global apparel footwear companies with more than $100 million in revenue that do business in New York, which, as you can imagine, is a lot of the big names players have stores in New York, so that a lot of companies would be subject to this. And the law requires, among other things, the companies to map a minimum of 50% of their supply chain and disclose where in the chain the companies have significant real or potential adverse social and environmental impact when it comes to things like fair wages, energy, greenhouse gas emissions, and then disclose targets for prevention and improvement of those impacts. And if you're found to not be in compliance, you could be subject to monetary penalties, 2% of annual revenues. This Fashion Act is making its way through the New York State Senate and Assembly, and with a potential vote date sometime in spring 2022. With that, I'll hand it over to Laura to discuss the metaverse and digital fashion.
Thank you, AJ. So I think in 2021, the metaverse and all things digital really came to the forefront. And I think it's going to have it's already had a significant impact in fashion. And I think it's only going to grow as consumer demand for digital fashion and more engagement in this metaverse actually takes place. So, what is the metaverse? You don't really know what it is, but it's really, it's basically the internet with a lot of virtual reality, augmented reality, and you're basically living in a digital world. So things are going to be intangible and digital and not going to exist in real life, IRL. I don't know if you guys remember, but when Facebook came out with their new name, Meta, who can really forget Mark Zuckerberg in that ad walking around like in the metaverse? So I guess that's what we're supposed to think that it is. But there is a role for fashion in this digital world, and they've already had a big role in it, especially coming from gaming. I think a lot of the esports and digital sports was an entree for fashion companies to get into this space, because consumers in that space wanted to outfit their avatars with maybe their favorite brands. Also, the advent of NFTs, which come from the blockchain, that's another way for the fashion industry to engage in this metaverse and allow another way to engage with their customers by allowing NFTs from their brands to be outsold, resold, and to kind of continue the brand engagement. So I think any brand really needs to consider the metaverse, what's their strategy, and particularly as it relates to trademark rights and IP rights. And here's just a few examples of what some brands are doing in this space. Balenciaga, for example, collaborated last year with Fortnite, so players could get their brand's looks for their avatars. Gucci had a collaboration with Roblox, which also allowed them to outfit it. Even Ralph Lauren also had a launch of their own digital apparel. And I know that this is just continuing. Just recently, Forever 21 did a collaboration with Roblox. Nike's doing one. And I know that real money goes into buying Robux in order to play Roblox, because I pay for it for my 9-year-old. So there's real money in this digital fashion that's actually changing hands in this space. And so what are the legal considerations for brands that want to become more involved in this? So the first thing we should look at is, what does your trademark portfolio look like now? And is that going to be enough to cover it? So if you're a brand owner in the fashion, apparel, and beauty, you probably have registrations in classes 25, 18, 14, and 3. But do you need to extend that coverage, or does that coverage extend already under the notion of natural zone of expansion? That may be something to consider, whether you have to take a look at your current trademark registration, see if you have to expand into other classes. And some of the classes that could be where you want to expand would be class 9 for downloadable items, 35 for retail of these virtual items, and even 41 in the entertainment space could be something you're looking at. And of course, for a lot of brands that are not just in the US, you have to have these same considerations when you're thinking about your foreign filings, and especially mindful in first to file jurisdictions. So should you reach out already, even if you haven't immediately started in this space? Should you start thinking about expanding into those classes in these first to file countries in order to avoid a squatter? And in China, for example, not only do they have first to file, they also have those persnickety subclasses that always make it difficult in terms of trademark prosecution. So you might not want to fight off a squatter because you don't have a registration in class 9 and you're limited to 25. So there are a few brands that are kind of at the forefront of trying to get protection for their trademarks in these other classes. Nike, of course, has filed for registrations for downloadable virtual goods in class 9, retail stores featuring these virtual goods and entertainment services providing non-downloadable virtual footwear. And it's notable that Nike recently purchased a huge company in the digital fashion space, Artifact. They're known for their digital sneakers that fetch like tens of thousands of dollars for, yes, a digital pair of sneakers. And Nike just bought them. So they obviously believe that the protection's important. Ralph Lauren, too, they recently filed their own application for similar goods in class 35 and 41 to cover this virtual metaverse goods. And this one we found interesting too, was it's for the configuration of a product. And so this is interesting when you're thinking about how to ward off infringement. Infringers are crafty, and they know that if they don't use the actual trademark on something, that it may be harder to protect. But if you're actually trying to protect the configuration of something, and that appears on an NFT, for example, even without the brand owner's trademark, this may be another way of trying to get protection in this, quote unquote, metaverse. So it might be a good strategy if the configuration, meets all of the requirements and is something well known enough to have that secondary meaning for consumers. But it's something to consider, especially as NFTs continue to grow in importance and prominence in this industry. So another really important thing that we just see kind of going on in this area is smart fabrics. What are smart fabrics, or also called functional fabrics? They basically are textiles that give a function beyond just the value of the fabric itself. So it's basically wearable technology. It's fabrics that can respond to a particular stimuli or environment. So it can keep you cool if you live in Miami when it's really hot, or it can keep you warm, like if you're like AJ or Jenny who live in the Midwest where it's cold. Or it can change color if there's some kind of electrical stimuli. It's also, used a lot in terms of monitoring, your heart rate, and for, those kinds of fitness apps can now be embedded into the textile and fabric itself in order to monitor these, your vital signs and other healthcare matters. So there's two types of ways that smart fabrics can be smart or functional. There's the aesthetic one, where, as an example here given, it could light up if you touch it, or if you press an app on your phone, it could change color. So that's more of the aesthetic functionality. And then there's the performance one that I mentioned, that it could change for your temperature, or it could it could have antibacterial qualities. There were some fabrics coming out, especially at the beginning of the pandemic, that were touted as, oh, we have antibacterial properties right on our fabrics that could help prevent getting the virus. So these kinds of new fabrics and any kind of new technology like this makes one think about, okay, well, what are the legal implications? What should we be thinking about? And for brands that are looking to look into this, are you coming up with something genuinely novel, a process of making the textile that's genuinely unique, or some kind of invention that could be patented? That's something that you could look into. Are you creating something that has a function that, like a very specific camouflage design, for example, that could be capable of copyright protection? Of course, trademarks are always another option if you're coming up with a great new name for something. So these are all the considerations one has to think about when they're thinking about smart fabrics, and I'm sure there'll be many more. And if anyone is interested in learning more about this, there's a great organization called the AFOA, Advanced Functional Fabrics of America. And actually, they're having a Smart Fabric Summit in March. So this is becoming a thing, and I think it's just going to continue. So we're running a little short on time, but hopefully, AJ, you can wrap up by giving us a preview of the cases that we're going to be watching in 2022.
Yep. So the first one is Peloton versus Lululemon. It's like a battle over athleisure wear. So these two parties had a co-branding partnership for apparel that Peloton ended. And then in September 2021, Peloton launched its own apparel line for, its exercise bikes and its everything, treadmills. Lululemon wasted no time. In November 2021, they sent Peloton a cease and desist letter alleging that 6 of Peloton's products infringed Lululemon's design patents or trade dress. Most of the products, as you can see here, are these sports bras, I believe. And then there was one other product was some of the leggings. And then, so Peloton filed a declaratory judgment action seeking non-infringement and invalidation of Lululemon's patents in the Southern District of New York. Lululemon responded then by filing its own lawsuit in the District of California. And recently, in January 2022, Lululemon filed a motion to dismiss Peloton's declaratory judgment action as an improper anticipatory action and wants the litigation to play out in California. Lululemon kind of alleged that there may have been some funny play going on with Peloton and that they, asked for more time to respond to the demand letter, only then to run to the courthouse and file an action first in their jurisdiction of choice. So we'll see how that one plays out. And then the next case we'll be watching is Airmass versus Rothschild. Rothschild launched a collection of 100 Meta Birkin NFTs featuring furry renderings of the iconic Birkin bag. These are over here on the screen, as you can see. And then to protect its iconic brand and trademarks, Airmass sent Rothschild a C&D letter and then subsequently filed a lawsuit in January 2022. The complaint alleges claims of trademark infringement, false designation of origin, dilution, and cyber squatting. Rothschild has not answered yet, but is likely to mount a First Amendment artistic expression defense based on his public comments. I think he's been airing out all of the lawsuits and the demand letters to his social media following. And this kind of ties into what we talked about earlier with the when brands must, when something goes too far and you actually have to act to protect your brand over these, artistic expressions. Because Rothschild previously had made a pretty, I thought, grotesque Birkin bag with like a fetus inside of it, an NFT one. But I think it was only a one-off, so Airmass didn't take any action against it. But they decided to act here. I believe Ray is going to jump back in with...
Yes, thank you, AJ. At this time, I will announce the CLE code. For those seeking CLE credit today, please type the following into the box on your screen and hit the submit button. The code is OD0G9. Again, that is O as in October, D as in dog, Z as in zebra, 0 as in zebra, G as in golf, and 9 as in November. We will leave the box open briefly. One last time, the CLE code is OD0G9. And back to Laura.
Okay, well, great. So hopefully everybody got that CLE code. And I don't think we have any questions. That means that we did such a great job that you guys didn't have any questions. So unless anybody has anything that they want to put in the chat, in the questions, I don't see any right now. I think we're done for this year, but as always, we're going to continue monitoring this, and always you'll get a survey after this, and please let us know if there's any particular topics you want us to be covering. We do webinars throughout the year, and so we'd love to hear from you if there's anything in particular you want us to cover for you. Otherwise, we thank you all for your time, and we hope you have a great rest of your day or night, depending on where you are. So thank you all so much.